District of Texas is now open and soon.
You may be seated. Good morning. I will be presiding over this morning's oral arguments. To my right, I've got Justice Lori Brissett. To my left, Justice William Mesa, and we welcome you to the Fourth Court. At this time, I'm going to call the case, and I will take announcements. This is cause number 425-0046, CV, Boynton, Williams and Associates, PLLC versus Dilley Independent School District and Gallagher Construction Company, LB, DBA Gallagher Services. I'll take announcements.
Morning, Your Honor. My name is Stephen Maroney. I'm counsel for Appellant. Williams and Associates.
Yeah.
Brendan McBride, co-counsel here, Michael Cavito for Appellee. We're ready.
Very well. You will each have 20 minutes, and then Mr. Maroney, you will have 10 minutes for rebuttal. You may proceed.
May it please the court. And before I begin, if the court will indulge me, this is my first time. I only have one opportunity to say that. It's a privilege to be here. This is my hometown. And again, it's a privilege to be communicating and talking about this appeal today. There's one issue before the court. That is, what does the practice in the area of practice of the defendant requirement within the Certificate of Merit statute mean? And this is in reference to CPRC 150-002 subpart A, subpart 3. Now, to be qualified to execute a Certificate of Merit, an affiant must practice in the area of practice of defendant. In this case, my client, Appellant BWA, was the architect of record that provided professional services to Dilley Independent School District. The area in question relates to that design of Dilley ISD's K-12 facility. That additional practice requirement from Chapter 150 must mean something. The legislature intended it to mean something. The 13th Court of Appeals found that it meant something. In the instant matter, BWA provided professional architectural services for a K-12 facility to a public school district. The suit underlying this appeal relates to Dilley ISD's K-12 facility that was designed by my architect, BWA. Now, the history of Chapter 150.
Mr. Maroney, may I ask, has any court, to your knowledge, recognized the construction of a K-12 school as, or designated it as an area of practice?
Specifically related to a K-12 practice, not that I'm aware of, but the 13th Court of Appeals did recognize that design of a hotel or other similar commercial structures to be a specific area of practice when the Mays Court found the Certificate of Merit produced by IDL to be insufficient because IDL is a forensic architect and didn't practice in the area of practice of Mays and threw that case out.
So is it enough that it's a commercial or a similar commercial building? Does it have to be a school that he has experience with?
Our position is that, yes, it does need to be a school. It does need to be a K-12 project. And the reason being is that the selection process, K-12 designed by architects is particularly specialized. Not anyone can just show up and say, I'm an architect, let me design your K-12.
But to what extent do the allegations or the specific claims in this case, to what extent are they relevant to our determination of the breadth of area of practice of the defendant? If the allegations or claims have nothing to do with specific design for a school and more to do for just a commercial building in general, why should we go more narrow than that?
The reason why, because the legislature has said that's what needs to occur.
So let me go back to my original question, Bevitt. To what extent do we look at the claims made and the allegations made in the case in determining how broad or narrow the area of practice of defendant should be in that case?
That would be the second part of the issue. The second part of, or maybe even arguably the third part of the Certificate of Merit requirement, that the affiant identifies some facts and reasons to support the claim of negligence or whatnot. The
No,
fir-
I'm specifically talking about our determination of what is the area of practice of the defendant. We will be determining the narrowness or breadth of that. And the question I have is, should we look to the claims made and the allegations made in the case, or are those for some reason not relevant to our determination?
I would argue and posit that they would be subsequent. No, they are not relevant to the initial threshold assessment of the affiant's
Are there
qualification.
any cases talking about that issue?
To the best of my knowledge, I don't believe that there are. There still is a requirement that those allegations, that the wrongdoing is enumerated and expressed in the certificate of merit. That's in one of the bottom sections. The first part, you've got to be licensed and you have to show that you practice in the area of practice to sign that affidavit. And in this particular instance, in this particular case, the claimant, the appellee's affiant told us he doesn't practice in the area of practice. He told us during his deposition, notwithstanding what he wrote down in his certificate of merit, that he had never provided those services to a public school district anywhere in the state of Texas. His experience in that regard is zero. Now, he made some other allegations about some wrongdoing, to your point, Justice Brissett, about some of the wrongdoing that occurred, but he never got past that first threshold, meeting the practices in the area of practice of defendant requirement in order to sign and execute the certificate of merit.
So what guidance do the courts give us in determining or interpreting the area of expertise of a defendant? And given that there's not a lot of case law relating to this statute, would it be appropriate to look at analogous statutes like TMLA, the Medical Liability Act?
I would posit that it would be. And as a matter of fact, whenever the legislature was working on the definition of the area of practice, separate and apart from what's required under the certificate of merit requirement, it specifically referenced, just like what happens in the medical malpractice statute, I think it's chapter 74, where a claimant has to go out and get a report from a qualified medical physician who's familiar with the standard of care of the defendant doctor and so forth. I would posit that it is very similar, if not the same, as that requirement. And it makes sense. It's reasonable. It's reasonable to say if you are making a claim against a pediatrician, that you go get a pediatrician to author a report to support that claim. The same thing in architecture. One practice of architecture can be distinctly different from another practice of architecture. You've got to make sure that the left hand and the right hand are on the same page talking about the same things. And in fact, the Mays Court decision from the 13th Court of Appeals was very specific about that. It struck Iddle's affidavit, who is a forensic architect.
What were the allegations in Mays? What were the specific construction defects?
The specific construction defects, there were two parts to it. The first related to the structural engineering design. Let me back up for 1 second. In the Mays dispute, there was a hurricane and it damaged a hotel. And then the owner of the hotel went through subrogation, and the claim was actually asserted by the insurance company under subrogation and so forth. So as a result of that, there was structural engineering, and there was the architect who retained the structural engineer. And that's the reason why there were two claims that were about that. Specifically, as far as I can read, the claims in the Mays decision related to the structural engineering design of that hotel project. Now, the 13th Court of Appeals threw out Mr. Iddle's affidavit because Mr. Iddle is a forensic architect. He had never designed, as far as I know, a hotel before. He had never retained a structural engineer to provide structural engineering services for a hotel project. Basically, Mr. Iddle had no basis, didn't meet the requirements within the statute to author the affidavit.
You say is a forensic architect, meaning he only comes in afterwards to tell them what they did wrong?
I think that's a fair summation. Basically, a forensic architect can show up on Monday morning and identify things that were done incorrectly after the fact.
So could that not have been the distinction the Mays court found with his affidavit, that he had actually never designed something affirmatively?
I think that's a fair summarization of how that court ruled on that, correct? And since we're talking about Since we're talking about the practice requirement, there are two different thresholds within the certificate of merit requirement. The first threshold is a broad threshold. It's to aid and advise a litigant if they even need a certificate of merit. In some instances, whenever an owner or somebody is filing a claim against an engineer or an architect, they don't need a certificate of merit. If it's a breach of contract claim related to a fee dispute, no certificate of merit arguably is needed. It's a big definition in referring to the Texas Occupation Code. The more narrowly tailored definition that we're talking about, practices in the area of practice of defendant, deals specifically, it's smaller, it deals specifically with the area of practice of, for example, my client, BWA, and the services they provided to Dilley, the public school district related to the K through 12 facilities. It's smaller.
Didn't he have something in his affidavit that he'd had provided at least consultation with the district? Why is that not sufficient?
That's an excellent question. Mr. Fiebig is Appellee's affiant. Mr. Fiebig, within his affidavit, number 7, as a matter of fact, said and testified that he was providing professional architectural services to a public school district in the state of Texas. However, the nature of those services related to litigation. It was to identify things that another architect had done incorrectly and was providing architectural services on how to address that.
So repair type services.
Correct. It was repair services specifically related to building and site drainage. It had nothing to do with, as far as what Mr. Fiebig told me, it had nothing to do with the other allegations that are asserted here today. And the reason why that's important is that practicing architecture for a K through 12 client, it's challenging, it's difficult. There are a number of different hurdles that an architect has to clear in order to provide those services. They have to be familiar with the Texas Education Agency requirements. They have to be familiar with the school district's facility plans. They have to be familiar with the various code implications. For example, in a K through 5 facility, the toilets are shorter. They're only supposed to be 12 inches above the finished floor, as opposed to an adult facility where it's supposed to be 18 or 19 inches. That's an accessibility standard that's required by the state that an architect who works with and provides professional services to a school district has to be aware of.
But here we're not talking about toilets being too tall or too short. We're talking about roof leaks and seepage, walls with openings where bats were nesting in between walls, HVAC that didn't work. So how is this, why should we restrict it to a very, very narrow, that we have to say it's the expert must be one who designs. And not only that, I think the further restriction, as I read everything I've read, is that not only is it's your client's position that it should be someone who designs schools, but it should be someone who does new construction. You can't, am I right about that? So explain why we would need to restrict it so much.
I'll back up for a quick second. The distinction between new construction and renovation, what matters the most is who is the owner? And the reason being is that, as you mentioned, HVAC issues, roofing issues, the EIFS issues, all those things cost money. In school districts, especially public school districts, some of them are cash rich, some of them are not. And if you were an architect providing professional services to a school district, you have to meet all those different requirements, such as the TEA requirements, task requirements, and so forth. But above all, you need to make sure that you are providing a solution that is reflective of your client's budget.
I also understand that the drainage system was a problem or is a problem. And from me reading Mr. Fiebig's, might have been in his deposition testimony where he talks, or his report talks about how far from the building these drains should be, at what slope, what grade, things of that sort. So how does that money factor into a decision like that?
The owner can direct and the architect can recommend that the drainage coming off the roof gets hard piped into a pipe underground. Imagine that's more expensive. It costs more money. Sometimes an owner doesn't have the budget to do that, and so you sheet train. That's part one. Part two is that in some instances, it's reasonable to interpret that code provision that requires water drainage not to cross a public right of way. It's a code requirement that the water draining from the roof doesn't do that. But the architect and her consultants may provide a reasonable solution that faithfully interprets that code provision to not result in a hard pipe. Basically, the architect and the consultants can provide or recommend a solution that meets that code requirement based on their interpretation, but also is respective of the owner's budget. Sure, you can hard pipe it into the ground. You can do that. And without doubt, that closes the doubt window in terms of whether or not we've met the code requirement. The question then becomes, can the owner afford it? And in some instances, they can't. In some instances, they can't, and that's not wrong. There are other methodologies or other ways to accomplish what the code is directing the architect and the owner to do. That's why being familiar with working with a K through 12 public school district is important. It's understanding and being respectful of their budget to make sure that they're getting the most building for the dollars that they have available for it. And I'm gonna-
5 minutes left.
So are you saying that a architect that had designed K through 12 schools before would take a different position on the design of this thing because of the code? Is that what you're saying?
I'm saying that I think an architect that regularly practices and provides services to a public school district client would look at what decisions were made, what recommendations were made by my client BWA to say whether or not you met the standard of care, whether or not you were acting in good faith towards the client's budget, as opposed to a forensic architect who shows up Monday morning and says, there's water on the ground here, it's your fault. And that's it. That's
Are you saying Mr. Fieberger is forensic architect only?
Yes. That's our position.
Okay.
That's what he's testified to. I understand, and I'll certainly not take it away that Mr. Fiebig and his firm does some design work, but they don't do work for public school districts in the same way.
So you're saying he's forensic in relation to schools, his work in schools?
Correct.
Okay. If we were to agree with you and affirm your point of error or reverse the trial court, what would be the appropriate remedy? Would it be rendition to dismissal or would it be remand for opportunity to cure?
There's two parts to that. First, it would be to remand, enforce a dismissal. And I would say that the dismissal should be with prejudice. The certificate of merit statute allows dismissal to occur with or without. If the remand involved a determination whether or not dismissal should be with or without prejudice, that would be reasonable as
So
well.
this statute is unlike TMLA in that it does not provide for an opportunity to cure?
Correct.
Okay.
I will also add that this project, the school district is subject to the statute of repose, which is 10 years following the date of substantial completion. I don't have that date specifically, but what I can say with certainty is that there's still time. Mr. Fiebig is not the right pony to ride in this race. Mr. Fiebig is a forensic architect who does not practice in the area of practice of BWA. Mr. Fiebig does not meet the requirements that are imposed by the legislature, and they put some time and effort into revising those qualifications imposed upon an affiant. First, it was practice and went to knowledge, and now it's practice again. So the legislature has been intentional about that. All to say, Mr. Fiebig isn't the right affiant for that. There is still time, to the extent that the court does agree with this position, that it should be dismissed. The plaintiff, the school district, Appellee, still has time, still has an opportunity to retain another architect that does meet the practice definition imposed in the certificate of merit statute and continue its litigation.
And you're saying the specific area of practice is the design of a K through 12 building?
That's correct. There are numerous different requirements and regulations regarding the design of a school building, much in the same way that there are different rules and requirements related to the design of the courtroom that we're in today. There are different standards that you have to meet. And even if something isn't wrong with those standards, as an architect, you have to be familiar with them. You have to be responsive to them in order to provide to your client an appropriate level of service, again, to make sure that they get the most building out of their dollar. If you are just showing up on Monday morning to identify what the issues are, you don't have to worry about any of those issues. You just get to say the building is leaking and it's your fault, and that's it. I believe that's why the practice in the same area of practice, practicing the area of practice of defendant, I believe that's why that in qualification requirement is important, is so that whichever the affiant is that shows up, understands what some of those processes are like and identifies wrongdoing, as it were, appropriately.
But you're saying as far as BWA, that would be the area of practice in this case,
Correct.
because BWA just doesn't construct K through 12 buildings, do they? Or design?
Their practice is broader than just K through 12, but I will add, and part of it was in our initial brief, if you look at Jay Boynton, who's the B in BWA, he's provided through BWA has provided professional architectural services to no fewer than 6 school districts across the state of Texas on no fewer than 30 K through 12 projects. So even though they've done a fair amount of work for Indian reservations and a variety of other clients, they do a fair amount of work for school districts. It constitutes a large part of their business. And the claims that are being asserted here relate to the school design, relate to the K through 12 design.
Your time is out.
Can I ask one follow-up question,
Sure.
if you mind? Going back to the issue about the standard of care, I want to make sure I understand what you're arguing. Are you arguing that the standard of care is different relating to a school design, or are you arguing that the standard of care for construction is the same, but a school architect might make different decisions about how to meet that standard of care?
The argument is that the standard of care arguably would be applicable across the board regardless of the project type. But the standard of care, as it's enumerated in multiple sources, does require a practice element, that the person, that the architect providing services according to the contract, according to the rule that the legislature adopted under CPRC Chapter 130.0021, that they're familiar with what it means to provide those services in the same circumstances and area and so forth. So that practice requirement that we're here talking about today is reflective in numerous other sources to say, you've got to practice in this area of practice. That's how you determine whether or not somebody, an architect or an engineer, breaches standard of care. The legislature in the Certificate of Merit statute was not pulling that requirement out of thin air. There's numerous other sources that impose a similar practice requirement on an architect that is providing those services.
I can understand where the different area of expertise would either mean a different standard of care or where a different expert would not have knowledge of the standard of care. What I'm understanding you're arguing is the standard of care is the same whether you do drainage for a school or drainage for a commercial building, but a architect that has school experience may make different decisions to meet a budget. But in the end, if they make a decision that doesn't meet the standard of care, there's liability, they could be liable, correct?
That is correct.
So if the standard of care is the same, regardless of what kind of building it is.
I would emphasize and encourage reading what the standard of care is. It's an architect that's customary, that's aware of and has provided the customary services in the same circumstances, in the same geographic region. That's what the standard of care, that's what the standard of care was in this agreement between BWA and the public school district. That's what the standard of care requirement says from the legislature. It's being familiar with that practice area. It's being aware of and having experience practicing in that area of practice. How can an architect say you did something wrong for the school district, having never practiced for that, for a school district ever before?
Now, this is a certificate of merit, which really the legislature imposed this statute to weed out frivolous claims, right? To make sure that someone certifies that there's merit to the claim.
Correct.
So it's a preliminary determination, but if, you know, if a plaintiff meets this threshold, to your point, couldn't you file a motion for summary judgment once you get into? Because we know from a practical standpoint that whether Mr. Feebig stays, assuming that this case is not dismissed, he may or may not be the plaintiff's expert at trial.
Correct.
Do you agree?
The only distinction that I would make about that, and you're correct, we are still able to file a Delaware Robinson challenge. We may still file a motion for summary judgment based on any variety of theories. And in fact, there's some mistakes even referenced in the brief that was submitted by the district. The main thing though, and this is what I would like to emphasize, is that if the court allows an applicant to creatively misrepresent their practice experience, it renders useless that certificate of merit requirement. It means anyone, any architect can show up. I can show up and say, hey, the defendant architect did something wrong. That's not what the certificate of merit statute stands for. And that's the reason why it's important to maintain that standard, to maintain that bar, to make sure that the applicant clears it. Not relying on misleading or obfuscating language to disguise the fact that they don't practice. We didn't know that he didn't practice until he told us, I've never done that before.
Thank you very much.
Thank
We've
you.
asked you many questions past your time.
Thank you.
You'll have 10 minutes for rebuttal. Mr. McBride, you may come up to the podium.
Good morning. May it please the court. Brendan McBride, along with my co-counsel, Michael Gavito, and we represent the Appellee, Dilley Independent School District. This interlocutory appeal is fundamentally a matter of statutory interpretation. So the court's role here today is to look at the language of this statute and figure out what it means. And the parties have very, very differing interpretations of what this concept of same area of practice means. You just heard from Mr. Maroney. He did an excellent argument on how it has to be the actual design, basically from scratch, of a K-12 school facility in order to have testified about faults in the design of this building by the architect BWA. And his argument there is, well, it must mean something to have that requirement. It does mean something. It just doesn't mean what he says it means. And there's nothing in the language of this statute or anything referenced in this statute to suggest that that's what it means. So if you're going to say that the ultimate use to which the building is going to be put is the fact at issue that has to be, that defines the area of practice, that's an arbitrary line that isn't based on any language in the statute. And under the well-established rules of statutory construction, that's not something the court should be doing. We're supposed to construe the statute, all of its language, to give effect to everything, rendering none of it meaningless, and with a mind toward achieving the intent of the statute. And with that in
I
mind,
think you'd also agree that we can't read the same license and the area of practice as meaning the same thing. Those are two different things. Right?
Correct.
So he has an architecture license. So what would you contend area of practice of the defendant means in this case?
I would contend that area of practice means that he has experience doing design or design analysis work for the issues and systems that are at issue in the case. So the things that he's critiquing in his affidavit.
So you're saying the allegations and claims are relevant to our.
Yeah. You're absolutely right. A license is not enough, because that is what the Levinson Alcorsair case is from the Texas Supreme Court. You can't just show up and say, I have a license. I don't think you can read anything more into that case at this point. That was a peculiarly awful affidavit. It just said he had an architect's license. If you go to the occupations code that's referenced in Chapter 150, there are different kinds of architects. I mean, he could have had an architect's license because he was an interior designer or a landscape architect. There was nothing in his affidavit, at least according to the court in Levinson Alcorsair, to tell what he'd ever done other than he had a license. So yeah, you're absolutely right, Justice Massey-Brissett. License is not going to be sufficient by itself. There has to be some additional facts showing why the expert, he or she, has experience that is pertinent to the criticisms they're giving of the defendant, no doubt. But That leads me to one of your other questions, which is, Mr. Maroney conceded to you that it should probably operate the way that Chapter 74 operates. And I agree with that. And I think that's probably what the Texas Supreme Court will do with it when they actually get to weighing in on this. Just an aside, by the way, Levinson-Alcozer has no in-depth textual analysis of the meaning of area of practice. It is in passing reference. Even the Mays Court acknowledges there's really nothing in Levinson-Alcozer or from the Texas Supreme Court as to what they think this phrase means. So my guess is, however this turns out, one of the other of us is going to be petitioning to try and get an answer to that. But we'll see. But going back to this idea of Chapter 74, I think that's probably how they will resolve it. And one of the things that Mr. Maroney argued was, well, if you've got a case against a pediatrician, you have to get a pediatrician. Except that's not the law under Chapter 74. What you have to have is somebody who is familiar with the standard of care that is at issue in the case. So you could have a general family practice medicine person talking about deficiencies in standard of care by a pediatrician if that family practice doctor does the same sort of things that they're criticizing the pediatrician for doing, like, I don't know, diagnosing the flu or doing a standard physical or something like that. So yeah, that just isn't the law in Chapter 74. And I don't think it's going to be the law on this if and when the Texas Supreme Court ever gets around to
much
it.
of your time, but what comes to mind for me as an example of a medical malpractice case would be in the area of surgery, where you've got, or you could possibly have you've got general surgery, you've got geriatric, you've got pediatric surgery, neurosurgery. Could a surgeon testify that a patient was not properly grounded before electrosurgery and therefore sustained burns? So it doesn't matter if the patient is a child or a geriatric patient or an adult. You don't have to be a pediatric surgeon to testify, the patient wasn't properly grounded.
Exactly, Justice Rios. Yeah, the classic example is you don't have to be an expert in orthopedic surgery if you're a surgeon that knows you're supposed to do a sponge count before you close the patient up. That's every surgeon can testify about how that's supposed to be done. But that's a great, I think that is a great way to think about how this is going to end up being handled. And then I want to combine that with another kind of general legal policy concept that's been really big to the Texas Supreme Court over the last decade or so. And that is this idea that when you're talking about issues at the outset of a case that are potentially case dispositive, if they're not done correctly, the Texas Supreme Court has been real clear that they very much want bright line rules so that when you file your case as a practitioner, you know whether or not you've done a good job of doing what's required to get this case on the books and keep it in court. And we've seen this with, most recently we saw it in an opinion under a Chapter 74 case. I think it's called Hampton versus Thome, Thome, that involved the 75-day extension on the statute of limitations when you provide the medical records release affidavit under the Chapter 74 affidavit statute. And the issue there was you can never really know for sure when you fill out one of those that your client hasn't forgotten a doctor or gotten the address wrong or a name wrong. So they're not going to have this draconian dismissal remedy for failures or faults in those affidavits. And so they reversed summary judgment on that ground in that Hampton versus Thome case. I think they're going to do something similar here. It needs to be a bright line rule as to who my expert needs to be. And I think the simplest rule for that is it needs to be somebody who is experienced and knowledgeable on the things that he or she is talking about. Which undoubtedly and unchallenged, Mr. Fiebig is. He is a national expert when it comes to the topics that he's talking about here, about the roof design, the drainage issues around the building, EIFS design, the exterior finish system, and especially on the issue of fireproofing, where he's a nationally renowned expert and has tons of experience.
He's not just a forensic architect, is that?
No, he does actual design work.
Read his affidavit to see.
That's correct. Yeah. But I want to turn to that issue too, because there's another interesting thing that came out of Mr. Maroney's argument, and that is that this very heavy reliance on the Mays case from the 13th Court of Appeals. If you'll bear with me, there's a bunch I want to say about the Mays case, because I think, in fact, that case actually strongly supports our argument, very strongly supports our argument. First of all, Mr. Maroney was very particular to keep mentioning that he's talking about the expert discussed in Mays called named Ittle, I-T-L-E. What he didn't talk about in this argument was that there were two experts involved in Mays. There was a guy named Kaufman, and there was a guy named Ittle. Kaufman was a expert offered on the issue of structural engineering. And then Ittle was the architect expert on the other certificate of merit affidavit. So I think you have to start that opinion by looking at both of those to understand what the court was thinking and doing in that case. The first thing they do is they point out, like I said, that Levinson-Alcocer doesn't really give any guidance as to what this term is supposed to mean. So they're kind of guessing as to what it means, same area of practice. They then get to, first, Mr. Kaufman, the structural engineering expert. And the argument was made there that, well, he's just a forensic structural engineering expert. So he's just a forensic engineer, not a structural engineer. The court says, no, when he says he does forensic engineering work, he does forensic engineering work in the area of structural engineering. Full stop. He is therefore meets the qualification of practicing in the same area. He provides a different sort of engineering service, but the area of practice is structural engineering. So engineers, they design things, they do forensic analysis of things, they do administration and planning, and that's all true of architects as well. So the Kaufman affidavit was actually held to be sufficient over this argument that he was only a forensic expert, which is one of the two arguments that's being made here. So Mays actually shoots down one of those two arguments on the Kaufman part. He also shoots down that argument with regard to the other expert. That's Ittle. So you look at the discussion of Ittle, and
So they struck Ittle on what ground?
on the ground that he was not in the same practice area, because he did not have anything in his affidavit indicating that he had, not because he was forensic, but he didn't have anything indicating that he had ever done any work on a hotel or other similar commercial project. A phrase so important to that court that they repeated it at least half a dozen times.
Were the allegations in that case relevant to specifically a hotel? And that was of concern?
No, they weren't, but the factual basis for his real world experience was almost nothing.
Mhm.
It was very similar to Levinson-Alcocer in that the affidavit had almost nothing about what he actually did for work.
Okay.
Importantly, though, later on in the opinion, this is the fourth paragraph after the section entitled Ittle's affidavit, where they're discussing that expert. They say, quote, moreover, Ittle does not state that he practices in the area of forensic architecture by evaluating the design of a hotel or other similar commercial building, the construction of a hotel or other similar commercial construction, including construction administration services. Presumably, if he did forensic work in those areas, just like they had just held with regard to Mr. Kaufman, that would have been sufficient. So actually what this case stands for is that Mr. Fiebig's forensic experience evaluating the design and construction of schools is very much relevant as his area of practice. The fact that he does some of it forensically and some of it as actual first-person design work isn't the distinction. The distinction is, what is he talking about? What are the criticisms that he has, and does he have experience to give those criticisms? And so this Mays case actually, I think, supports us far more than it supports the appellant, than it supports BWA.
So are you arguing that we should affirm the trial court because he has experience in the school area? Or are you saying we should hold that it doesn't matter because in light of the claims and allegations made here, he had relevant architectural experience?
Primarily, I'm arguing the latter, that he has a relevant architectural experience as it relates to the criticisms he has of the architect on this project, even if that weren't what the rule is. Secondarily, I'm also arguing he has experience as it relates to schools because he has forensic experience evaluating design and construction in numerous schools, and those are outlined in his CV. So he would meet that standard under Mays anyway. And I'm arguing third, that even if you disregarded his forensic work, he has actual design and construction experience in relation to consulting work as a design architect for a Texas school in Big Spring. Now, their argument is, well, that he only came to that because he started as a forensic engineer, but that doesn't change the fact that he is actually providing design consulting services to a school in Texas. And their other argument is, well, now we're narrowing it down even more, that it has to be somebody who designs the school from the beginning, not consulting work to repair it or remodel it. again, this is a statutory interpretation question. There's nothing in the statute that allows that to be the case. And if we were going to allow this sort of arbitrary moving line, then we have a real problem with how practitioners are supposed to even practice under this statute. I mean, if the meaning of the statute is as creative as the defense lawyer for the architect can make it, then who knows whether you've satisfied what you required to get your case on file and stay on file. So I don't think that the Texas Supreme Court is going to allow that kind of an argument. I think they're going to have a more general view consistent with what they've done with the TMLA, with Chapter 74, and they're going to say, while certainly just having the license isn't enough, if you've provided real architectural services or engineering services as part of your experience that relate to the issues that you are critiquing, then that's going to be sufficient, just like it is in Chapter 74. It does not have to be specifically somebody who designed a K through 12 school from the ground up. I would add that no one in this room is a licensed architect. So if we're saying that that's even a distinction in the field of architecture, we'd be making it up. There's nothing in the record that says that that's the way architecture is thought about or practiced either. The only thing on the record is from Mr. Fiebig, who says it's not. If you're designing a building, a building's roof or an eave system, and it's going to be used for a hospital, or it's going to be used for a warehouse, or it's going to be used for a school, that's kind of the same thing. It doesn't really make any difference what the ultimate use of the building is, because he's talking about the design of the system, which he knows a lot about, because he has real world experience doing it. That is his area of practice, those sorts of things, both forensically and as a design expert. So I think in answer to your question, I think there's a whole bunch of levels where you could affirm this. You can pick whichever one of those you want. You could pick all of them. I'd be happy with that too. But I think we're probably going to see from the Texas Supreme Court what they think about it. Maybe if it gets traction, we'll see. But I
Do the same question I asked him. If we were to agree with him, what's the appropriate remedy? Is there no opportunity to cure under the statute?
That's where it's a little different than Chapter 74. So Chapter 74 allows you to cure with a new report. This statute allows discretion in the trial court to either dismiss with prejudice or without prejudice, which would allow refiling. Now, that means that if it's at post limitations, the case is potentially over. So the remedy is a little different. It is a discretionary remedy in the trial court. My guess would be that, we're looking into the future at this point, but my guess.
Should we remand to allow the trial court to exercise that discretion?
Yes. Yeah, I think the trial court has to exercise discretion. Then you could review following that whether or not there was an abuse of that discretion in making the decision whether to dismiss with or without prejudice. My argument on this case is there's undoubtedly a good faith attempt to comply with this. And then going back to Chapter 74 again, that's the standard for allowing the curative report as well. This does appear to be an expert who knows what he's talking about, and there's a real genuine attempt to comply with the statute. So I think dismissing this case without prejudice would probably be an abuse of discretion, but that's for a later date, I suppose. So I think on those bases, I think the fact that the Mays case actually supports us. I think if you look at this in light of the bigger policy purposes of this statute and the obvious comparisons that it has to Chapter 74 and its purpose, that the Texas Supreme Court, when it gets around to construing what this requirement actually means, is probably going to announce a rule very similar to what they're doing on the TMLA, that Mr. Fiebig clearly meets that standard. He definitely knows a lot about and has a lot of experience in the specific systems that he is critiquing in this case. And for that reason, the trial court did not abuse its discretion in denying the motion to dismiss. And if there's no further questions, I'll yield the rest of my time back to the court.
Thank you very much. I have no questions.
Thank you.
anymore. Mr. Maroney, you may come up for your last 10 minutes of your first oral argument ever.
Thank you, Your Honor.
Mhm.
I want to respond to just a handful of points. First, I am a registered architect in the state of Texas. My number is 23977. I practiced architecture for about 9 years before I went through midlife crisis, became an attorney. The jury is still out if I made the right choice or not. So whenever I do offer an opinion or commentary about the practice of architecture, it's because I did it. I did it for a number of years. I'm married to an architect. I'm still very much active in the profession. I've taught courses at UTSA's College of Architecture. There are specific and unique subspecialties And I know that other courts have tried to veer away from that description, but the reality is there are subspecialties. Anyone can be an architect. I'm an architect. Not any architect can say that they are an architect for K through 12 clients.
But you would agree that there are some aspects of architecture that run across all areas, right? Roofs. Their standard for roofs are probably similar across commercial buildings and schools. Would you correct?
That is correct. I would agree that there are some unifying factors across the practice spectrum, much in the same way that there are unifying factors across the practice of medicine, that there are across the practice of law. Can I go appear in bankruptcy court? Sure, I'm a registered licensed attorney. I'm permitted to, I'm sorry, let me retract that. That's not the right example because I know that you've got to be barred separately. But nonetheless, I wouldn't be qualified to criticize an attorney that practices family law because I don't do that. Can I do it? Yes. Am I permitted to do that with my license? Yes. Can I offer a criticism of another family law attorney about how he or she litigated their case? No.
Unless it's a standard that every litigator should know regardless of what kind of case it is. If, for example, if they failed to file a special appearance before filing their answer, it doesn't matter what kind of case it is. That's a law, that's a rule that applies everywhere. So any kind of attorney could talk about that, right?
That is arguably true, but the legislature has given us guidance about how to assess a certificate of merit and affiance
And
qualifications.
it says area of practice of defendant. He's an architect. I would imagine there's difference between residential architects and commercial architects, but you're arguing for a very, very narrow reading of that. And my question is, why would that serve the purpose of the statute? The purpose of the statute is simply to say, this is not a frivolous claim. And if you look at the Supreme Court opinions in Chapter 74, they've watered it down judicially watered it down to say, as long as there's a good faith attempt to meet the standard and to show it's not a frivolous case, we're not going to dismiss it. Why would that not be the similar standard we should apply here?
In particular, the reason why this standard should be a little bit more narrow is that based on arguments that were just made and based on information in the certificate of merit, Mr. Feebig made mistakes. There is no dispute related to the fire treatment. It's called fire retardant. I don't like that word, but nonetheless, fire treatment of parapet walls. Mr. Feebig was looking at the wrong drawings whenever he rendered that opinion, and he actually withdrew that criticism. But now we're talking about it. Now Appellee's counsel is talking about it. Would a residential architect understand that and understand you've got to look at the right drawings? Arguably, yes. But would a residential architect understand the different code implications about why that's important, about why there needs to be fire treated wood on the parapets?
We're not talking, he's not a residential architect. He's an architect in the commercial space.
He's held himself out as a forensic architect. And I think that's an important distinction. The legislature has told us that's an important distinction. The area of practice of defendant, BWA, my client is not a forensic architect, doesn't practice forensic architecture.
What about his comments about Mays, that the forensic was not the distinction in the court?
Mays is an interesting case, and I would agree with him to the extent that in the Kaufman affidavit, the structural engineer, Kaufman's affidavit was sufficient. It did identify the fact that Kaufman had provided structural engineering services related to projects similar to the hotel in question. Iddle's affidavit didn't. And that's an important distinction. I think that shows how a court can, for lack of a better description, thread that needle to say, this passes muster. If this is included on the face of your affidavit, then you're good to go. You've met the intention, you've met the intent of the legislative requirement. If you don't have that information, you haven't passed muster. You haven't shown that you practice in the area of practice related to the dispute that's before the court. Admittedly, and you're absolutely correct that there are some aspects of practice that are broad that every architect, every engineer, every lawyer, every doctor should be familiar with or responsible for. That's not what the legislature imposes here. The legislature in no uncertain terms says you have to practice in the area of practice of the defendant.
But it's how you construe that. And there's nothing in the statute that tells us how to narrowly or broadly construe that.
That's a good question. Candidly, I don't know.
Because it could be that it's commercial architecture.
I would-
Or it could be that we take into account the allegations and claims into Mr. McBride's statement that as long as this person was licensed as an architect, had experience in similar commercial architects or similar buildings, and was knowledgeable enough to render an opinion on the issues at issue in this case, that is area in the practice of defendant.
Then it renders the area and practice of defendant meaningless.
Why?
Why not? And I'm sorry, the reason being is that any architect arguably would be or should be familiar with envelope design, with roof design, with site drainage.
I would understand that there's differences between residential, commercial. I would understand that there's difference between an office high-rise and a hotel high-rise because there's different systems, right? But doesn't it come down to what is the question that the expert is being asked to opine on? And if that's an issue that runs across any kind of commercial architecture and he has knowledge of it, why is that not a reasonable reading?
I would argue specifically because public school district clients, they're unique. It's a high burden to even get in front of a public school district to provide professional services to them. Like I mentioned before, anyone can be an architect. Not anyone can say, I practice that kind of architecture. And the reason being is that public school districts have particular needs. They have particular budgetary constraints. They
But
have,
none of those particular needs of a school are at issue in this case. Is that right?
that is correct, but you can't divorce what those requirements are from the issues that are in this case. You can't separate that. You can't show up as an architect or as a school district or as an attorney and say, I'm only going to focus on this issue. All these other rules and regulations and things that are important to you as an owner, they don't matter. I'm only focusing on the water, or I'm only focusing on the pleading, or I'm only focusing on blood pressure. You can't do that.
So going back to Judge Rios's analogy, would you say that if the question is whether or not how they did a sponge search before they closed the person up in surgery, that a general surgeon couldn't talk about an orthopedic surgeon's standard of care?
I think that you could, to the extent that the general surgeon is familiar with that, but I've never practiced surgery, so I can't say for certain, but performing a knee replacement versus open heart surgery versus brain surgery, against any of the different varieties
It
of
comes
surgery,
down to what is it the issue that the expert is opining on?
or in general, what the area of practice the expert is opining on. And in this particular case, it was a public school building. It was subject to a public school building's budget. Yes, it implicates the envelope. Every building has an envelope, including this building. This building has a waterproofing system and so forth, keep the outside outside and the inside inside. This building probably most likely has an A occupancy standard, so does a movie theater. Does that mean that an architect that designs a movie theater can come in and be critical of the architect that designed this space? Even if that architect that designed the movie theater has never looked at the judicial standards, the jail standards that are required regarding that door and the door that's behind me and the number of doors that I walk through. The answer to that question, I think, is no, that there needs to be some awareness and there needs to be some practice experience within that realm in order to qualify as an expert raising those types of criticisms of an architect, even if the criticisms are broad, even if the criticisms relate to a scope of practice that every architect arguably should be responsible for.
You have 15 seconds.
I believe that this court should overturn the lower court's decision when it denied the motion to dismiss. And thank you for your time.
Thank you very much. We are adjourned. You will, your case is submitted.
Don't forget
Yeah,
that.
we are adjourned. Thank you very much.
My apologies, I didn't know you were up. No, it's okay.